I'm going to cover some reflections on the day and some things from our perspective at the Ombudsperson's Office that I think are very important to understand about the Victims' Bill of Rights. And I'll start with saying that it is, in fact, the law. The Victims' Bill of Rights is the law. It's quasi-constitutional. It was passed by Parliament with the intent and express objective of changing the way that we do criminal justice in Canada. And the courts are obligated to interpret the law according to the intent and objectives of a law. So the preamble of the Canadian Victims' Bill of Rights says that victims of crime not just have rights in the Charter of Victims' Rights, but have charter rights, the Charter of Rights and Freedoms. So that's clearly established. It clearly establishes that consideration of victims' rights is in the proper administration of justice. And it says that it's important that victims' rights are considered through the entire continuum of the criminal justice process. That alone, I think, is very impressive. We'll unpack it a bit more. Arrow? Shazam! And the Friday magic trick here?
Just kicking on the profile.
Okay. So, I see. All right, fine. So we skipped the slide and I don't know how to go back. So I'm just going to say, it said, things are changing. All around the world, things are changing. Legal systems are recognizing the rights of victims and survivors. And it's a change that's inevitable in Canada. And we have to choose how long we'll dig in, right? The law has a history that's embedded sexism over time and has a history of prioritizing the rights of men over the rights of women. The continued lack of enforcement of victims' rights reinforces gender inequality in Canada, and does it often in the name of the Charter, in protecting the rights of the accused. It's a terrible paradox, and it has to be remedied. Sorry, it's because I'm like amped up now to get through that I'm being a little more bold than I might if I was using my careful voice, if you don't mind. Marie indicated earlier that there'd been a change in the UK with the Victims Code, which is lovely. There's a kind of a very clear code. I want to highlight that in 2024, they also passed a bill called the Victims and Prisoners Act that established legislation to support who was already the Victims Commissioner and now is the Commissioner for Victims and Witnesses. And it introduced an obligation for the state in all of its different parts connected to criminal justice to consult with the Victims Commissioner on issues that intersect with the code. So if they want to change the Victims Code, if they want to look at how it's going to be enforced, if they want to look at awareness, they must consult with the Commissioner. That duty applies to the Attorney General, to criminal justice systems. It introduces the duty to cooperate with the Commissioner for public agencies and a duty to respond to the Commissioner's recommendations. I'm going to give a little bit of feedback on what we've been hearing about the CVBR through the lens of a national systemic investigation that our office has launched on how survivors of sexual violence are being treated across Canada in the criminal justice system. Sorry. So we have a number of inputs to the study. We interviewed many survivors. We have a survivor survey with 1,000 responses, but we have a stakeholder survey with 450 people, about 100 Crown attorneys across Canada and other professionals and people working in sexual assault centers. But we asked how familiar people were with the Canadian Victims' Bill of Rights. So they did better than the general population, because I think a justice study a while ago showed 17 to 19% of Canadians had heard of it before. So we see that there's growing familiarity, but still there's people who aren't very familiar, and some of them are Crown attorneys. And Parliament has passed the Canadian Victims' Bill of Rights as a critical tool to interpret how criminal procedure should be playing out related to victims of crime. We asked how effectively the CVBR promotes its rights, and you get a continuum of responses. A lot of people on the end here, they didn't know enough about it to know how effective it was, but we see that some rights are weighed a little more heavily. The darker bar there is that it's very effective, and the little light bar at the first side is that it's not effective, okay? And so there's mixed feelings about some of them. We see that the right to protection and right to request restitution are seen to be the weakest of the rights currently within the bill. Sorry, the charter. In the past 5 years, we asked, how do you perceive that the system has changed? And so stakeholders felt like there'd been an increase of people who were being informed about their rights under the Canadian Victims' Bill of Rights. So most people said it stayed about the same, but more people felt like it had increased and decreased, which is encouraging. When we asked survivors about their experience with the rights in the CVBR, we see this unfortunate bit that shows, like, were you told that you had the following rights? The right to request an update on the status of the investigation. 27% said yes, 9% said no. And this is one of the main problems with the CVBR, is that the right to information is upon request. It makes no sense. We wouldn't accept, like, at face value, if the rights of the accused were upon request. If you arrested somebody and they had to ask you what their rights were, or they had to ask you if they could access a lawyer, and, you know, like, we tell people because their interests are affected. Their charter interests are affected. For survivors, their lives are affected. Their personal safety and security is affected. The least we can do is tell them about the rights that they have. It doesn't make sense to withhold that information. It's irresponsible. Sorry, I'm being too strong. But it's what we hear. We hear the human cost from survivors, and we've heard it for years, and we've spoken about it for years. And when the law was first proposed, survivors and advocates said, if you don't make it automatic to give this information, you're not going to remedy a lot, because that's the gateway into other rights, which the office has argued in the past. But I want to say, if this is a quasi-constitutional law, currently, like there's power in the law now, right? We just need to grab those pieces as well. So the obligation for participation and protection is on the state. It's not on the victim to request those things. The state has to guarantee that those rights are upheld. There's a responsibility there. And so I think that can be quite transformative, but I'm going to keep moving and unpack it another time. And then we asked if CVBR rights should be enforceable. This is a very sad question in some ways, because it implied that they're not. And I do think that they are in some ways. Like, as a federal complaints mechanism, we're able to negotiate directly with federal agencies, and we often can resolve issues that victims and survivors are having. But there's limits. And so 67% said, yes, it should be enforceable. Only 9% said no. And the others, again, were like, I don't know enough to weigh in here. And I think that's significant. We asked, like, more specifically, this question is awesome, by the way, and I have to say that Crown attorneys were at the very top end of these answers. Should survivors receive the following information automatically? Their rights in the criminal justice system, 98%. Yes, right? How to access independent legal advice, 93%. Yes. If we have actual independent legal advice available for survivors of sexual violence and intimate partner violence, and we don't tell them, again, we're creating a barrier that affects people's safety and security, child custody. Like, there's so many impacts. And all that it takes, all that we're asking, is to tell people about it, to give the information, like, this is how you can contact that program. Restorative justice programs that are available, 86% said yes. Peace bonds, investigation outcomes, charge decisions, publication bans, and how to have one removed. I know a couple of those are double-barreled questions. I apologize for our very rapid methodology as we scaled up, but they're still valid. All right. And so we're at a tipping point, I believe, in victims' rights. One of the biggest challenges that is kind of coming into the public sphere right now is the Supreme Court decision of R.V. Jordan. This was a decision that has very good interests at its core. Like, people need timely justice. The accused has a right to timely justice, and a victim has a special interest in timely justice. That was acknowledged by the Supreme Court. The outworking of this is an imposed timeline for how long a trial can take, and if it passes that threshold, the charges can be stayed, right? There can be an application for that to happen. So in April, the media began to report that there was a lawsuit from survivors. This is a civil lawsuit against the federal government about R.V. Jordan and the Canadian Victims' Bill of Rights. So 14 survivors, I think it's 14, are suing the federal government because when their cases were stayed, they experienced immediate and horrific impacts on their personal safety and interests. One woman had to leave the country because of stalking. One woman had her child abducted as soon as the case was stayed. This is not okay. It violates the right to protection that is the responsibility of the state to uphold. And it highlights this conflict between the rights of the accused and the rights of victims. One of the appeals to the Supreme Court on R.V. Jordan was in a case of femicide. And the case, continues to be stayed, and the commentary noted, again, the interest in timely justice for victims, but not the loss of life or the other interests that victims have. And in general, we need our public institutions to do a better job of recognizing the interests of victims of crime, taking responsibility for remedy, and creating ways and pathways to make a change. How are we doing? Okay, I'm right near the end here. So one of the things that we've seen is that the R.V. Jordan decision isn't just about stays. That's the tip of the iceberg, but it's affecting decisions across the entire criminal justice system. So there might be a delay in laying charges, even though we know that somebody's at risk, because we don't want to jeopardize the Jordan clock. And so survivors are having, there's a gender-based discriminatory impact of R.V. Jordan in how charge practices are rolling out in Canada. We're seeing sexual assault cases proceed as assault cases because they're going to be faster and more likely to result in a conviction. And we see that preemptively cases are dropped. Time is going on and are like, oh, I don't think we're going to get this done in time. And so the case gets dropped at that point. And so it's all of these different decision points that are being affected. And we've seen it increase motions, allowable motions from the defense. So even though the intent was to reduce the amount of time that cases were taking, if there's a timeline and your defense counsel and you can introduce motions, do it, right? Like and so we get this effect where, if you can subpoena someone's counseling records, that's an allowable part of making a defense. If you can use court time to object to a survivor having access to testimonial aids so that they can participate more safely during cross-examination, if it's allowable, do it, right? And so there's some easy ways to help offset the impact of Jordan on survivors by strengthening protections for victims of crime in the criminal justice process, making it more automatic that testimonial aids are given if somebody needs them to participate safely, will save court time and rescheduled hearings and that knock-on effect. Okay, I'm just going to show two last examples of positive developments that are happening around the CVBR, because I want to end on a happy note. In 2020, there was a Supreme Court decision. This little guy comes from a footnote, but that's encouraging, where the Supreme Court justices felt that it was, they say, we note that neither the trial crown nor the judge referred to the provisions of the criminal code or the Canadian Victims' Bill of Rights. This is a case where the person wasn't able to give a victim impact statement. And so they're kind of sharing this expectation to consult the CVBR where it affects victims' rights, like testimonial aids. victim impact statements. And then most recently, this thrilled me, as the Senate was concluding its final clause-by-clause decision to establish the new Miscarriages of Justice Commission in Canada, which is very interesting. There was a debate between independent senators and conservative senators, largely, where they were both arguing for the CVBR. And it was beautiful. It was like, yes, our message is getting out there. It's quasi-constitutional. So on the one side, the senators were saying, like we argued too, and I still think it's important, that the law should explicitly bring in the rights under the CVBR into how victims will be treated when they interact with this new body. And on the other side, the opposition to that was saying, oh no, it's already quasi-constitutional. It's already going to have to comply with the provisions in the CVBR. That for me is a turning point. When the Senate of Canada starts adopting that perspective, and it was convenient at the time, because if it went back to the House, then they'd have to like kill the bill essentially. But it was so encouraging to hear that. This is a quasi-constitutional bill, and like the Human Rights Act in Canada when it was introduced in other bills, it needs the space to breathe, it needs the space to develop, which has to happen by victims having access to standing and to appeal. So, you know, there's this easy way to improve the bill just by taking some scissors and cutting off the bottom lines, which would let people challenge their rights in court, and it would make it enforceable just by removing those clauses that say there's no standing, there's no right of appeal, no cause of damage, right? Like that is not language that is connected to rights. It's the antithesis to rights. And so that has to change. So rather than going through things, I'll say that our office is going to release a 10-year progress report on the CVBR. We did one for the 5th that was passed around Parliament, and I'm really hopeful that this is a time of change. And I believe that there's momentum, and I'm so thankful to see all of you here because this matters, and it affects people, and they don't always get to be heard. And so using your voices and working together, we're going to see this change. It's time. And it's time to end this discriminatory impact on women. It's not acceptable. And it's time to catch up to the momentum in other countries, learn from each other, solve our problems together. And I believe that we can do that. So I'm just going to give some closing thanks. Yeah? Donc, merci au Centre de justice pour les victimes d'actes criminels pour l'organisation de ce colloque, un événement qui requiert tant de logistique. Merci. Oui, Marissa? Marie-Claude, Marie-Claude, merci. Merci beaucoup. Ce fut un plaisir pour notre bureau de collaborer avec ces professionnels qui ont une mission si similaire à la nôtre et avec qui nous partageons les valeurs de respect, justice, inclusion, d'écoute et d'empathie. Un gros merci aussi au Centre international de criminologie comparée pour le soutien financier. Et l'événement a été financé par les fonds d'aide aux victimes, un programme de subvention et contribution administré par le ministre de Justice du Canada. Et congratulations on another fantastic year of Victims and Survivors of Crime Week and all the work that you do to put together those conversations that help us advance in Canada. Stephanie is the director of the Policy Center for Victims' Issues. And she's like the best of what the public service has to offer, with like a heart of compassion and a heart to see things done ethically and fairly, but also so that survivors are heard and treated well in the system. Je ne peux pas imaginer une meilleure façon de conclure la Semaine des victimes et survivantes d'actes criminels de 2025. Merci beaucoup. Have a really nice time, everyone.